Bar Rules Series. Business Associations.
Corporations. A corporation is a legal entity that exists separate from its shareholders, thus shielding the shareholders and managers from personal liability for the actions of the corporation. Formation. De jure. A de jure corporation is one that has obtained full legal status as a corporation by meeting all statutory formalities. De facto. A de facto corporation is one which has failed to meet all the statutory formalities but has made actual use of corporate power in the good faith belief that the formalities have been met. The law will treat such an entity as a corporation and will shield shareholders from personal liability. Estoppel. A party who holds out an entity as a corporation or who deals with an entity under the belief it is a corporation cannot deny corporate status. Such estoppel only applies to liability under contract. Powers. A corporation may be formed for any lawful business purpose. Ultra vires. Under common law, acts outside of a corporation's stated business purpose are void. Modernly, such actions are valid to protect the interests of innocent third parties. Liability for pre-incorporation contract. A promoter of a corporation is personally liable for pre-incorporation contracts until there has been a novation. A novation requires that the corporation assume the liabilities of the promoter with the agreement of third parties. A corporation is not liable for pre-incorporation contracts unless the corporation adopts the liability or accepts the benefits of the contract. The promoter is still liable until there has been a novation. Directors. A board of directors is the governing body of a company, elected by shareholders to set strategy and oversee management. The directors act as one board. Voting. Voting by the directors must be independent. To achieve a valid vote, there must be a quorum of directors, and the action must be approved by a majority of disinterested directors. Duty of care. Directors must act in good faith and as a reasonably prudent person in similar circumstances. Business judgment rule. Actions taken by a director have a presumption of good faith and are presumed to be in the best interests of the corporation. The presumption may be rebutted if the director's conduct is unreasonable. Decisions by the directors must be independent, but it is reasonable to rely on expertise of others. Duty of loyalty. Directors must act in the best interests of the corporation and put the corporation's interests above his own interests. A breach of loyalty occurs if the director engages in action which create a conflict of interest. Self-dealing. Self-dealing occurs when the director, or someone with whom the director has a close personal relationship, benefits from a business transaction with the corporation. To cure the conflict, the director must disclose the relationship and get board authorization. If the transaction has already occurred, the director may rebut with entire fairness, which requires the court to determine that, after close scrutiny, the transaction was objectively fair to the corporation. Usurping a business opportunity. A director or officer may not act personally on a business opportunity if it is in the corporation's usual line of business and the corporation would expect to be presented with the opportunity. The director must disclose the opportunity and only act personally if the corporation declines. Competition against corporation. A director or officer may not directly compete against the corporation. Duty to disclose. Directors and officers must disclose material information relevant to the corporation's business interests to the board. Shareholders. Voting rights. Shareholders have only indirect corporate power through their election of the board of directors, and the right to approve fundamental changes. Each share of stock carries a particular voting right. For an action to pass, there must be a majority vote of a quorum of votes, which is usually a majority of the outstanding shares. For a fundamental change, there must be a majority of all outstanding shares. In cumulative voting, a shareholder can cast all their votes for one director. Shareholders may make agreements with other shareholders to vote a particular way, or may delegate their votes to a voting trust, where the trustee votes for the trust. Lawsuits. A direct lawsuit is one where a shareholder sues for a breach of duty owed to the shareholder, resulting in personal damages. Derivative lawsuit. A derivative lawsuit is one where a shareholder sues on behalf of the corporation for damage to the corporation. To have standing, the shareholder must own stock. Before filing suit, the shareholder must first make a demand on the board to bring the suit, unless the shareholder can show futility or urgency. Liability of shareholders. The shareholders of a corporation are not personally liable for corporate acts, and they are only at risk to the extent of their investment. Piercing the corporate veil. The limited liability of shareholders for the actions of the corporation is subject to challenge if a plaintiff can pierce the corporate veil. If successful, a shareholder will be personally liable for corporate actions. Piercing the corporate veil can be accomplished under the doctrine of alter ego or undercapitalization. Alter ego. Alter ego is established when the shareholder fails to treat the corporation as a separate entity, and instead treats corporate assets as his own. This can be shown by commingling of personal and corporate assets, use of corporate assets for personal gain, and failure to follow corporate formalities. Undercapitalization. Undercapitalization occurs when the shareholder's monetary investment at the time of formation is insufficient to cover foreseeable liabilities. In such situation, the use of corporate liability protection is seen as a bad faith attempt to avoid risk. Controlling shareholder. A controlling shareholder is one with voting power to have substantial impact on corporation. Not necessarily 50%. Such a shareholder may not sell to looters, eliminate shareholders, or make unique distributions. Securities laws. 16b. Short swing profits. Insiders of a corporation on a national exchange or with $10 million in assets may not retain profits from short-term trades made within a 6-month period. Such profits must be disgorged to the corporation. 10b-5 Securities fraud. Fraud or deception in connection with the purchase or sale of securities through interstate commerce violates Rule 10b-5. Fraud is established when there is 1. An intent to commit, 2. A material misrepresentation or omission, and 3. The claimant's reliance on it. In cases of insider trading where there is no identifiable claimant, the action may be brought by the government as a fraud on the market. Insider trading. Insider trading can be established against an insider who directly trades, or against a tipper who shares non-public information for an improper purpose. A tippee may also be liable if the tippee knew that the tipper breached a duty, and the tipper personally benefited. Misappropriators are liable if they obtain non-public information by breaching a duty owed to the source of the information. Fundamental changes. Fundamental changes are actions that materially change a corporation's business or structure, such as merger, amendment of articles of incorporation, dissolution, winding up, and share exchange. Fundamental changes require a board resolution and approval by a majority shareholder vote. Dissenter's right of appraisal. A shareholder of a closely held corporation who does not agree with a fundamental change may have the right to force the corporation to purchase their shares based on an appraised fair market value. Agency. Agent. An agent is one who agrees to perform for the benefit of principal, subject to the principal's control. Independent contractor. An independent contractor is one who agrees to perform for the benefit of the principal, but who maintains the right to control over the method and manner in which the contractor performs. An independent contractor is not an agent, and the principal is not liable for the torts. Principal liability in contract. A principal is liable for contracts entered into by their agent if there is authority. Authority may be express authority, exists when authority is expressly granted by the principal. Implied authority exists when the agent reasonably believes that they have authority because of necessity, custom, or prior dealings. Apparent authority. Apparent authority exists when the conduct of the principal leads a reasonable third party to infer that the agent had authority. The agent is said to be held out as having authority. Ratification. A principal will be liable for contracts, even when there is no authority, if the principal engages in conduct that accepts and approves the agent's action. Lingering authority. Authority may exist, even after termination, if a third party reasonably relies on a written expression of authority, and no notice of termination was given. Agent liability. If an agent acts without authority, or if the principal is not disclosed, the agent is personally liable. Principal liability in tort. Respondit superior. An employer is liable for the tortious acts of his employee if the employee commits a tort while working in the course and scope of employment, but not for tortious acts of an independent contractor. Actions are within the scope of the relationship. 1. If the conduct was of the kind the agent was hired to perform. 2. The tort occurred while so acting. And 3. The agent intended action to benefit the principal. Exception. If the employee substantially deviates from the scope of employment for personal reasons. A frolic. The principal is not liable. However, if the employee's deviation is minor, a mere detour, the conduct remains within the scope of employment, and the principal may still be held liable. Intentional acts. A principal is not liable for intentional acts unless the act was specifically authorized, was the natural result of employment, or was motivated by a desire to benefit the principal. General partnerships. A partnership is an association of two or more people to carry on a business for profit. No formalities are required. Each partner is an agent of the partnership. Liability of partners. All partners are jointly and severally liable for the actions of the partnership, unless the partner is a limited partner. Liability of the partnership. The partnership is liable for the actions of each partner performed in the scope of the partnership. Business or made with the authority of the partnership.